A very pleasant evening to all the distinguished panelists and participants. Bharati Vidyapeeth Institute of Computer Applications and Management BVI-CAM in association with Computational Intelligence Society chapter of IEEE Delhi section, Computer Society chapter of IEEE Delhi section, Technology and Engineering Management Society chapter of IEEE Delhi section, System Man and Cybernetics Society chapter of IEEE Delhi section, Communication Society of IEEE Delhi section, Consultants Network Affinity Group of IEEE Delhi section, Life Member Affinity Group of IEEE Delhi section, Inter-Society Relations Standing Committee of IEEE Delhi section, Industry Relations and Special Interest Group on Humanitarian Technology Standing Committees of IEEE Delhi section, with the associations Computer Society of India, Institute of Information Technology Professionals, IITP, ISTE Delhi section, and IETE Delhi Center as technical collaborator, welcomes you all to the webinar on the topic Simplifying IPR and Patent Filing. It is a moment of pride and honor to announce that we, with united hands, mark special contribution for the monumental occasion Azadi Ka Amrit Mahotsav, an initiative to celebrate 75 years of glorious independence by organizing the thought-provoking sessions for our better future. This webinar is an initiative for the celebration Azadi Ka Amrit Mahotsav. Inventions cannot be judged on patent parameters, but the patents have the ability to take the invention so far. With the rise of intangible assets that are shared across the internet, it is easy for people to unlawfully copy and share books, music, movies, and more. Copyrights, patents, trademarks, and trade secrets, and the laws around these protections are all intended to encourage innovation and creativity and are essential to the practice of IP law to help curb illegal activities. The webinar will discuss the Indian patent filing procedure, unleashing IPR, display of various patent design, patent filing journey from application to grant stage. I would first take this opportunity to welcome amongst us our distinguished panelists for the day. We are privileged to have amongst us a galaxy of experts. I would now like to welcome and request Professor M.N. Huda Sir, Director, Bharati Vidyapeeth Institute of Computer Applications and Management, BVI CAM, and Vice Chairperson, IEEE Delhi Section, to please address the participants with his inspiring words. Please, sir.
Good evening, one and all. Am I audible, Ayushi?
Yes, sir.
Yeah. So today I was in attendees list. First, I didn't get the connection. I'm outside, not at home, not neither in office. And then I was in attendee list, and I was trying to contact Uttam that can change my rights. So anyway, I'm here. So I take this opportunity at the outset to welcome my today's valued speaker, Mr. Awab. In fact, 99th webinar was supposed to be delivered by him, but he had an exigency at his home, and because of which he could not. And today he is with all of us to enlighten us, to make us to understand how to simplify the process of IPR and also the patent filing. My dear friends, I also take this opportunity to welcome my friends from all professional societies who have collaborated with this program after program. And this is 102nd webinar of that series, IEEE, IETE, BVICAM weekly evening webinar series. This is 102nd program of that series. So I also take this opportunity to welcome my all friends, participants from various parts of the country and abroad who keep on waiting for this program and keep on reminding me that Saturday has come and you have not shared the link details with me, particularly those who keep on waiting for my WhatsApp, for my messages. So thank you so much to all and each and every person who has joined for this program. My dear friends, this weekly evening webinar series was started in June 2020 with one objective of connecting people for the purpose of some professional grooming, professional learning, and dissemination of information. That objective is being fulfilled week after week, and the people from various parts of the country and abroad based on their interest, based on their area of specializations, are joining for webinars after webinars. Today's webinar, as all of you know, are basically to simplify the intellectual property rights, IPR, and patent filing. And all of us know those who are in one or other form are in a position to produce something, to generate something, to utilize something even, are always in a dilemma, in a kind of a difficult situation to understand whether to publish it first or whether to patent it first, whether to put it in a public domain and there is no violation of copyright, there is no violation of intellectual property, or whether to get it checked through a kind of some softwares, etc. So, and this problem will continue to grow, and this today's session is going to enlighten us that how and in which way this entire process can be simplified, so that without any hesitation, without any fear, without any concern, we should be in a position to publish our document. We should be in a position to share our intellectual properties. We should be in a position to share our services and product whatsoever we are. And that's how, while receiving papers for our publications, we have international conference being organized since last 17 years. 17th edition is happening this year. We have a journal which is being published since last 15 years. And when we write back to the authors that, Baba, you haven't written your intermediate results, you have not given your entire research methodology in a self-explanatory manner in your paper. And then you will be surprised to know that what the response we get from the author's back, that is my confidential data. I cannot share the intermediate result at this moment. Maybe that's a part of some funded project, that's a part of some PhD work, and that's my intellectual property. But please understand, even if it is your intellectual property, if you do not share complete details well in advance in the paper to me or to any publication, possibly the publisher will not have the faith in that paper, will not have a faith in that intellectual property, and may not publish it. So under that circumstances, I always advise to my authors that you need not to publish it first. You may go to file an IPR, you may go to file a kind of a patent. Once you have filed the patent, then you are sure that no one else is going to use it, and then you come back to me and publish it, or come back to any of the publisher and publish it. That's the background with which this program has been organized. So thank you so much from various parts of the country. Let's understand, it is a very, very important topic, very important concern. Directly or indirectly, every one of us are involved in that. Even if we are using some property, some intellectual property, or some trademark, or maybe some kind of document, and we are not aware of that, if we are violating in some or other way some of the law, possibly this ignorance will not save us. So this program, this session will also enlighten us that how and in which way we should be comfortable while using the services rendered by other, the intellectual properties rendered by others, or how to ensure that my property should get published, my intellectual right should get published, my intellectual property should get patented, etc., etc. So thank you so much. With this note, we'd like to conclude that हमेशा की तरह जैसे वो अमिताभ बच्चन करोड़पति में कहते हैं ना कि अगले अगले हफ्ते फिर एक नए एपिसोड के साथ मिलेंगे, वैसे ही है कि फूलों की तरह फिर खिलेंगे हम, फूलों की तरह फिर खिलेंगे हम, और अगले सैटरडे एक नए टॉपिक के साथ फिर मिलेंगे हम. Thank you so much. Wish you all the best. God bless you all. Stay safe, stay healthy. The corona new version of the COVID is again rocking China. Possibly around 70-80% of the country is under lockdown. So let's be safe. Let's stay safe. Let's take all precaution. Thank you so much. Wish you all the best. God bless you all. And Ayushi, over to you.
Thank you, sir. Thank you for always motivating us. I would now like to welcome amongst us our expert speaker, Mr. Awab Habib Faki, sir, with an e-bouquet. We welcome you, sir.
Thank you, ma'am.
With firm belief in innovative education and years of experience in entrepreneurship, Mr. Awab Habib Faki, sir, Director, Student Alliance, LLP Mumbai, is a multifaceted professional. He has established his own edtech startup, conducting independent research and patenting several inventions. Also, he is a startup mentor at the Atal Incubation Center and as the mentor of change at Ministry of Commerce and Industry, Government of India. With many awards and recognitions to his credit, he is an educator at Al Kalsekar Technical Campus, an edupreneur, a patent analyst, and a researcher. He has numerous patents filed till date. Mr. Awab is also on the governing body member of the Everest College of Engineering, Aurangabad, member and advisory board member, Board of Studies and IPR cell, Maulana Azad University, Jodhpur. He is undoubtedly an experienced professional in the domain of patent grant and filing. We are privileged to have you amongst us today, sir. I welcome the great visionary and request him to please enlighten the house. Please, sir.
Thank you so much, Aisha. Can I share the presentation with your permission?
Yes, sir. Sure. Sure, sir.
Thank you, ma'am. So, Ayushi, ma'am, can you view my presentation?
Yes, sir, I can.
Okay, thank you so much.
Thank you, sir.
A very, very good evening to everyone. Thank you so much for having me, especially Amin Huda sir. Uh, Basically, in coming, like I have almost like 43 minutes, so I'll make sure that coming 43 minutes is very productive. That is completely my responsibility. Uh, we'll be having a small journey about an overview about the patent and what are the steps of filing a patent. People who have not filed it and people who are having their work and how to proceed ahead for it, and people who have already having a knowledge for it. Will be having some legalities for it. Okay, what are the hurdles if you are facing some hurdles if your patent is rejected? How we can overcome that phase and we can go ahead with it on a positive note. So let's go ahead with it. Firstly, my dear friends, we need to understand why it is called as a property. Normally, we hear properties as in like we have an asset. Like we talk about flats, we talk about rooms, right? Where we can sell it, we can earn money from it, and we can give it on rent or we can trade on it, so on and so forth, right? Similarly, my dear friends, when you talk about over here, this is known as property because with this, you can have a trade, you can sell it, or you can give on a rent, and so on. So basis, like when I talk about rent, that means you can give it for on a license based for a 2 years or 3 years and so on and so forth. Okay. So my first question to this amazing audience, what we have today, like we can make the chat room little more interactive so that coming like 44 minutes, we can make it more interactive because even there are points which I can learn something from you and what I know, I can share it to you. Okay. So when you talk about IPR, intellectual property, okay, so are you aware how many types of IPR do we have? We have one, two, or three, or four. How many types of IPR? If we can just know, like just mention the number in the chat room. Let's make the chat room very interactive. Just mention the number. How many types of IPR are there under the Indian patent law? If anyone, thank you so much for being so sporty. Bhavesh and Anshuman have initiated. Thank you so much, Mr. Soma Sundaram. Thank you so much. Era Virendra Kumar ji, thank you so much. Thank you so much for making it so such a positive. Thank you so much, Ritik. Thank you, Pavan ji. Thank you. Very nice. So people have answered 4, people have answered 7, and so on and so forth. Few have answered 3. Thank you so much for making it positive. Anyone who want to make some guesses for it? How many types of IPR do we have it? Okay. So let's on a count of 5. We'll stop it. 5, 4, 3, 2, 1. So we have answers from Shraddha, Pratibha. Thank you so much for being so sporty. Thank you. Thank you so much. So when you talk about IPR, my dear colleagues, there are 9 different kinds of IPR. Among that, we like 3 of the IPRs we have, like everyone knows about it, like patent ho gaya, like we have copyright, right? We have trademark and so on and so forth. Okay. So there are 9 different types of IPR. We won't be going into depth of all the 9 different types of IPR, but at least we'll be discussing one of the type of IPR, that is patent. Okay. So before that, we'll be having a brief overview about an IPR. Thank you so much for putting in efforts. So the correct answer is there are 9 different types of IPR. So when you talk about objective, so again the objective is like either few of the points which has already been said. I would say my guru by M.N. Huda sir. When you talk about this thing IPR, it is all about to protect your work. We cannot say an idea and imagination. Like few of the people have a question mark. Can I protect my idea and imagination? No, you cannot. When you talk about your work, so your work should, when you show a result, like what sir said, when you show a result, there have to be a subsidy, working towards it. You cannot put a result and get a patent. You cannot put a result and get a publication. You have to have series of work. How did you get that result? Okay, so in that case, similar work happens in IPR. In this case, when you talk about objectives, one of the famous things as of now, which is going from 2021 to 2022, that is TOT, transfer of technology. Especially it is going between US and India, because in India, my dear friends, you cannot patent a software. Like I have seen few of the attendees are from a software background. So let me get it very clear on this. You cannot patent a software in India. Yes, you can patent a software in US, but in India you cannot. So if you would question me, Awab, can we go for a patenting for algorithm? No, you cannot patent an algorithm because it has a mathematical equation. By law of nature, you cannot do it. But few would say, like Ritik and Pawan and Shraddha would question me, okay, you said we cannot patent an algorithm. Can we patent the steps of an algorithm? So the question is yes. So the answer is yes, yes, we can patent the steps for an algorithm. Pratibha, I have put on the slideshow mode. Okay, thank you so much, Pratibha. And next is objective to maintain the harmony upon different kind of skill set of the people, so on and so forth. In that case, and to just encourage the community who are working into technological domain. So that's the major objectives of IPR. What we have. So the best way to predict the future is let's invent it, my dear friends. People have already done it. Let's see how we can protect it. Now let's understand few of the basics for it. Okay, so we have a family over here. We have Pratibha, we have Vijay with us, we have Shraddha, we have Pawan, Ritik, Virender, Eras, Anshuman, Bhavesh with us. Okay, if for example, if they would question me, or Pratibha would question me, oh, I am already having a patent, so I would be called as a patentee. So patentee is nothing but a owner of a patent. Now Pratibha would question me, oh, I want to give my patent, okay, to some other third party. In that case, what options do we have? So in that case, one of the options is that you can either lease your patent, you can give a license to your patent. You can either to Pawan, either to Ritik, either to Virendra Kumar, depending upon what is the demand and supply for it. Either Pratibha would say, no, I don't want to give on a license basis. I want to straight away sell it off. Okay. So in that case, it would be an assignee. So it depends what is your requirement. How do you want to go for it? Okay. Either you want to give it on a licensee basis, either you want to directly sell your patent. Okay. It depends how do we work for it. Since we are starting on a very positive note, assuming uh, everyone works is very patentable, so everyone is a patentee. So let's call ourselves as a patentee. Let's start on a positive note. So already we are having a patent. Let's see how to utilize it. If you feel, my dear friends, if you feel in that case your patentee life or whatever innovation you have done it, the life is not too big. So you feel the life of that product or that innovation is only 3-4 years. In that particular After that particular span, it will fade out. So in that case, you feel let's not give it on a license basis. The time span is very low. So instead of giving on a license, let's sell it off to a third party and let's take it in XYZ commercials and let's deal it off. So in that case, you go for an assignee and you give it to the a new entity. The entity could be a company or corporate or industrial person or pharmaceutical, so on and so forth. In other case, if Vijay, Bhavesh, and we have Gangadeep ji with us, if they feel if they have a patent, if patentee Vijay, patentee Bhavesh, patentee Gangadeep ji, okay, if all three are a owner of a patent and they feel yes, their innovation has a very huge life, okay, that is having a very huge life. In that case, they feel why should I sell it if I can enjoy the commercial for a very longer period? Let's go for a licensee period, and the licensee period could be a span of 2 years to 8 years to 3 years to 15 years to 18 years, maximum to 20 years, because the lifespan of a patent is for 20 years from the date of your application. So when you get a patent, so the total lifespan is of 20 years. So that is the time you can enjoy a licensee. After that, it becomes public. Okay, you won't be having rights for it. Apart from this, when you talk about licensing, like if Prakash ji would tell me, okay, let's assume everyone in this chat room is having a very, very good innovation. Everyone in this chat room is a patentee. Assuming ki their innovation is very, very productive, it will have a very good lifespan. Talk more about the licensing. Give us more in that, okay, how we can go for a licensing. When you talk about more about licensing, in that case, there are two categories. One is exclusive, one is non-exclusive. Okay. One is exclusive, one is non-exclusive. Let's understand both the categories when we can go for what. Okay. For example, you have an innovation. Okay. You have an innovation. In that case, you feel keep if this innovation I can give license to in 10 states to 10 different people. Okay. So I'll be earning like in 10 different manners, right? From 10 different companies. Okay. In other point of time, you feel ki no, it is a very riskier point ki to give a 10 different license. For example, if in any of the part of the state, the algorithm or the concept or so on and so forth, it is leaked. So it is very difficult to tap on ki it is leaked from which industrial area, and it is very difficult to control for it. So in that case, people will feel ki no, let's go for an exclusive one. Let's give to only one distributor, and he will be having the sole right for it to for the complete production. If anything goes wrong, even he'll be in a bigger loss. Even you will be in a bigger loss. So the responsibility is very higher in exclusive case, but it varies from person to person. What is your product and how fast you want to scale it? But obvious, when I talk about scaling perspective, when I talk about scaling perspective, my question is to the amazing audience. If I want to scale it in a much faster way in 0 to 3 years, which licensee will take an important role? Exclusive license or non-exclusive license? If you can answer it, just E or NE. That's it. E or NE. If you talk about if I want to scale it in a very short span, which license will take a very important role? Exclusive license or non-exclusive license? Thank you so much, Bhavesh. Thank you. You have been very active. You were the first person to reply. Thank you so much. Pavanji, it is not about exclusive is something you give to only one distributor in that territory. When I say territory, that means if you get, for example, you are for me, Pavanji, you are a patentee Pavanji, right? So you are a patent owner. So if you own a patent in India, right? So that is it is limited to Indian territory. Your patent in India doesn't is not valid in any other country. For example, any patent in US, it is only valid in US, so on and so forth. It is only valid in that particular territory. Okay. So if I want to scale very fast, so the things works out only when you have multiple license to multiple vendors so that they can have a good production and they can earn a huge profit or margin, and similarly you can also enjoy the royalty benefits. But the only question is that in non-exclusive, the how safe your product is, right? So we have to really understand key what is our product, what is the lifespan of our innovation. That can only be channelized by you and the industrial people who are approaching towards you. Okay. So that's a small brief about licensee, assignee, patentee, exclusive license, and non-exclusive license. Assuming we all over here are patentee. Let's go for the next one. So people would say, you told us about what if we are already we are a patentee. Okay, you told us we are there are two ways. Either we can directly sell it, either we can go for a licensee. Licensee again, there are two categories. One is non-exclusive, one is exclusive. Exclusive is you give license to one of the distributor. Okay, non-exclusive you give license to various distributors. Okay, thank you Achal for putting an answer in the chat room. If the same question, if I question you to this amazing audience, which licensee is a safer? Forget about the higher profit margin, forget about the aggressive sales, about the production. Which licensee is safe? Exclusive or non-exclusive? Thank you so much, Soma Sundaramji, for being so fast. So which licensee is safer? Exclusive or non-exclusive? So we have already got an answer by Soma Sundaramji. Thank you so much. Yes, exclusive is much safer than non-exclusive. Again, it depends upon your product. If you feel your lifespan of your innovation is very high, you should always go for an exclusive one. Thank you so much, Dr. Ashil, for putting an answer. Thank you. So let's understand few of the terms related to patent office. Okay, like I don't have to explain all the attendees over here. I feel they are all the dignitaries with us. Okay, about the technologies, you guys are extremely good for it. So I don't have to discuss more about the technologies. Assuming you already having an innovation with you, let's say you only want to go for a patent. So let's understand everything about the technicalities and about the patent office too. Okay. So when you talk about the patent office and so on and so forth, like how do we have like principal and directors in this campus? Like for example, for this session, MN Huda ji is the director for this Bharatiya Vidyapeeth campus, right? So similarly, we have a controller who is the highest authority into a patent office, who can like either accept or reject your patent. So whenever you find an application, it goes to an examiner, then from examiner it goes to a board, and then it goes to a controller. In that way, it goes. Dr. Achal would question me, ki, okay, for example, you have already said me ki I am a patentee, Dr. Achal, right? What if I've got a patent and Pavanji have a query on my patent, okay? Pavan and Bhavesh, Ira, Prakash, all four of them are questioning, I shouldn't get a patent for it. In under Indian patent law, is there any flexibility that they have a liberty that they can question it and they can raise a query? Yes, that is known as opposition board. Like we have a post grant opposition to under Indian patent law, where even after the patent is granted, the 12 months the window is open, like anyone can oppose it, and you both the parties have to give justification, and then a conclusion could be taken by a appellate board. Like how do like I have seen we have a legal assistant of for a high court with us in this chat room. So similarly, like how we have a district court, an high court, and supreme court, so on and so forth. Similarly, we have an appellate board over here who takes all this legality decision and report to the controller. So again, the patent office, all the legality has been executed by them. Like few would question me, Pavan ji would question me, Bhavesh would question me, Ira would question me, Prakash would question me, Sharma would question me, is it compulsory for an offline application? No, the answer is no. In fact, government is supporting you for an online application. In fact, they are giving you 10% off on your application fee compared to your offline application. There are 4 major offices in Pan India where you can directly go and do the offline application. I'll be giving you all the offices location also. Okay. But it is always preferable. You can go for an online application. It will save your time and money and everything. Okay. Second, again, a patent register. This is a very common question, very common question to everyone. Like Sandana would have it. Sandana is there with us. Uh, she People have a question like, do we have to compulsory hire a patent attorney or a patent agent? Is it compulsory? Like Prakash would question me, Gagandeep would question me, Pratibha Vijay would question me. The answer to this is no. It is not compulsory to hire a patent attorney and patent agent, but only if since you are really expert in your innovation category, since you want to only focus on your work and you want a third entity who have a really good expertise in filing a patent, who have a really good expertise in drafting a patent application, because drafting a patent application is very different from drafting a paper. Okay, when you talk about journal paper, so only in that case you feel ki, no, I want a third entity, only in that case you can hire for it, but it is not compulsory to hire a patent agent or patent attorney. Okay, in India, a patent register is something like all the communication with respect to your patent. For example, we have already assumed we all are a patentee. Okay, for example, patentee Bhavesh would feel ki, okay, if I'm giving my patent on lease, if selling my patent to some other, right? If I sell my patent to patentee Achal, so the Dr. Achal would be a new assignee, right? So in that case, all these records are mentioned or maintained into a patent register. All the transaction with your patent, that is also maintained with the patent departments. Okay, so that is what the patent register is all about. Okay, so yeah, if you have a question, patent recipes, when you talk about contents, the content it will come under a copyright category rather than patent. Patent is all about innovation work, Sandana. Okay, when you talk about recipes and content, that will particularly come under copyright category about the procedures. Okay, and Dr. Achal has a question may be raised after publication, or Dr. Achal, if you feel ki your innovation has that kind of potential, so Dr. Achal, my request to you is that ki wait for your publication. First apply for a patent. When you apply for a patent, in earlier days, like it used to take 18 months to come on the portal. Nowadays it comes on the portal within 45 days with You'll be getting a serial number for it, and all your documents are on the portal. And after that, you have to apply for the examination. And then, like even if before applying for examination, you can go for a publication. But first apply for a patent, then go for a publication. Don't go simultaneously. If you feel your work has that kind of potential, go for a patent first. Don't make it public. Okay. Whatever patent is so big that it could kill all the competition, what will happen then? No, it doesn't matter. It is all about your innovation. So that leave it to if you have that kind of innovation in that category. So congratulations, Bhavesh, for it. You'll be getting an request from all the corporate giants for it. So you should enjoy that royalty. So let's talk about the priority. So let's talk about some of the cases. We have Dr. Venu with us. We have Pavan with us, right? So these two people would question me, कि, wow, okay, you told us about few of the points about ki, what are the rules, like you told about the licensee, you already made us a patentee before even telling us ki how to file a patent, or you have already having a patent, then congratulations in advance. Okay, so tell us ki if we get a patent in India, okay, can we have a patent, global patent? Can we have a global patent? Okay, so if I question to all the audience in this chat room, can we have a global patent? What do you think? The answer is yes or no. You can just type Y or N. Can we have a global patent? You can just type Y or N. That's it. Thank you so much for putting an answer. Thank you, Dr. Uh, Dianesh. Thank you, Kamal. Thank you, Prameet. Thank you, Bhavesh. Thank you, Shraddha. Thank you, Anshuman. Thank you, thank you, thank you, thank you, thank you, thank you, thank you. Thank you, Dr. Supinder ji. Thank you, Dr. Sakshi. Thank you. Thank you for all your putting an efforts to answering into the chat room. Country specific, Dr. DNS. Thank you so much for putting an answer. So as it was already been said, the patent is straight. It depends upon your territory. So whichever country you apply for it, so that is limited to that particular country, my dear friends. Okay, you don't have known as something known as a global patent. Okay, nothing like that. So people who have said yes for it, they would question me, if you are saying we don't have a global patent, what if example we have to apply a patent, we feel ki our patent is having a lots of potential and it will work aggressively in 41 countries. 41 countries, like Baba said, if I have a very killing idea, it will aggressively work in 41 countries. Do you think I have to apply in 41 countries simultaneously and start working on it? How is it possible? So my answer to this question is, my dear friends, that is the reason the government came with a convention treaty. When I say government like this, that is nothing but a WIPO, World Intellectual Property Organization. They have made a convention group of countries. One convention group of countries is a combination of 148 countries, and the second one is 173 countries. Okay, so they have combined the initial filing procedures to make it simplified for the innovators. So in that case, the initial 30 months, the common application process, they have made it common so that you can save your time and money. And the examination process is different for every different territory. But at least the filing procedures, they have made it common for that particular country. Okay. So that is an advantage what we have. So if anyway you feel your student have that kind of potentials and you are a mentor for them, in that case, you can also think about convention group of countries applying to that platform and have a patent which can be from apart from Indian territories too. Okay. Let's talk about the priority date. We have Vishal with us. We have Dr. Dhyanesh with us. If they would question me, Dr. Dhyanesh and Dr. Vishal would question me, okay, we both were working on a similar project. Okay. Dhyanesh stays in Delhi, Vishal stays in Maharashtra. Coincidentally, they both were working on a similar project. Okay. Similar technology and so on and so forth. Dr. Dhyanesh have completed his 80% of the work and Vishal has completed only 60% of his work. Okay. And Vishal knows in coming 12 months, he will finish his work. Okay. And Vishal is aware about the patent process. Dr. Dhyanesh is not much aware about the patent process in that case, but is very firm with his technologies and his innovation. Is very well versed with it. in that case, what Dr. Dhyanish will do, he'll complete his work and do the application and then apply for a patent. Okay. What Dr. Vishal will do, Dr. Vishal will directly apply with only with the provisional application, and he will complete the remaining work in 12 months. Because in patent you have two applications, one is provisional, one is a complete application. Okay. And Danish will apply, he'll wait for 6 months, he'll complete his work and he'll apply with a complete application. Okay. So we have group A where Danish, his team is waiting for 6 months and then they will apply with a complete application. We have group B where we have Vishal Bhai and his team where they will be applying immediately because they feel in 12 months they will complete the work and they will resubmit the complete application, but they want to apply with the provisional application because they know they have an option known as provisional application. Okay, so that is group B. My question is to the amazing audience over here. What do you feel? Group A will get preference or Group B will get preference? Group A is Mr. Dhyanish. He will wait for 6 months. He will go with the complete application. Group B is Mr. Vishal. He is applying immediately, but he is applying with a provisional application. He will wait for within 12 months. He will complete his work and he will then apply. So Group A will apply after 6 months with complete application. Group B is applying immediately, but only with provisional application. What do you feel to this amazing audience? Who will get the preference for patent? Group A or Group B? My question is to the amazing audience we are having over here. Who will get the preference? Group A will get the preference or Group B will get the preference? Thank you, thank you, thank you. Thank you so much. Thank you so much, Vishal, Ira, Dr. Sakshi, Pawan, Bhavesh. Because in India, my dear friends, what do we do is that we have a priority date. India, it already there because, for example, if we talk about it terms from a patent officer, like they don't know what kind of work was completed by which of the team, right? And they have already created a segment known as a provisional application. So your application date plays a very, 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 very important role, my dear friends. Very important role. So you have to be very, very careful if you feel your patent plays a very, very important role and it could be like as Bhavesh said, it could be a market destructive innovation. Then make sure you apply with the provisional and then government gives you a 12 months of span where you can complete your work and submit the remaining part within that 12 months. So whenever you feel yes, your innovation plays a very important role, you should always go for a provisional. But in case of you feel no, your innovation won't play an important role into like industry or revolution kind of stuff. It will help the NGOs and other entities. It will be a non-commercial innovation. Then in that case, you can relax and you can wait for it. You can complete your work and then apply for it. So it depends upon case to case. What is your objective about your innovation? Okay. Again, we have already covered the basics for it. Let's go for it. Yes, Dr. Achal, it is possible. I'll come to this point. There are three categories how your patent is defined, and this is the slide patentability. So I think your question could be answered in this slide. If I'll try my best to answer it. So you would have a question कि अब ठीक है आपने कुछ बताया, आपने license ही बताया, आपने assign कुछ बताया. You talk about licenses. You talk about who are the people involved into patent officers. We have a controller, we have an examiner, we have a patent agent, we have a patent register. Okay, we have both the options. We have offline options, we have online options. Online option is 10% cheaper, right? The fees is 10% cheaper. It is always preferable to apply online. You already spoke about like that there's nothing known as a global patent, right? So we have an option known as convention group of treaties where you can apply to multiple countries with a common filing procedures. So we spoke about that. Okay, well, come on the crux point. Tell us about the clarity. How does an examiner into a patent office judges your application? If I apply for my application, if I am a mentor for my students, or if my research I have to apply for it, if my innovation I have to apply for it, tell me how it is exactly judged under Indian patent law, how the examiners are approaching for it. So these are the three categories, my dear friend, which is based on Indian patent law. how it is done for it. One is novelty. So when you talk about novelty, my dear friend, it is not about something extremely like you have to like completely out of the box. My only point is that the application should be different. That is what the examiners feel like. For example, if we talk about watch, yeah, the watch cannot be patented. So if you use a watch and if you use a chip, if you can make it smart, for example, then that is something you have added a new application to it, then you can patent for it. It is not like something new you have to make. You have to make sure the application, if the application is new, it is productive, that can be categorized under novelty category. The application should be new. That is really important. Okay, it is not required like it should be completely out of the box. Make sure the application should be new. That is really important. Second is your inventive step. In this case, I often take a common example. I'll take an example over here as well. We'll build from two groups over here. Okay. Okay. In group A, we will have Vishal, Dr. Dhyanesh, Prakash, Parmit, uh, Soma Sundaram, Bhavesh. Okay. And group B, we have Ira, Dr. Sakshi, Dr. Sukhvinder, and we have Karapagam, we have Dr. Achal, we have Pratibha with us. So there are two groups, Group A and Group B. Group A is already having a drug patented in their name, and that drug is for a cancer patients. And that drug, they are selling it for 8,000 rupees per month for a cancer patients. And it is doing extremely well into the market. Group B has the same capabilities and intellectual capabilities up to make the similar drug. If they observe the yes, that is doing extremely good and the audience is very huge and we can cater to n number of people and we can help them. So even they start working on it. And after a particular period of time, with lots of sheer efforts, their intellectual capabilities, their network, and their time, efforts, blood, and sweat, they were successful in making a drug with a different chemical composition. And the positive point was that the effect was all the complete same as that of the drug, which was made by the group A. The effect was also the same, even after using a different chemical composition, and they have kept the pricing also the same. So that was the efforts taken by the group B. Now, the question is to the amazing audience over here. You have this scenario in front of you. Group A, already it is patented. Group B, they used a different chemical composition and they were successful in maintaining the quality as well and even the price as well. So what do you feel? Will the examiner, the controller, will accept the patent of Group B? Y or N? That's it. Group B will get patent or not? It can be Y or N. That's it. Thank you so much, Dr. Sukhvinder. Thank you so much, Pawan, Dr. Sakshi, Kamal. Thank you so much for being so supportive. Thank you, thank you, thank you, thank you, Dr. Sukhvinder. Thank you, Dr. Sakshi, Pawanji. Thank you, Priti. Thank you. If the cost is less. So the answer to this is, my dear friend, because I'm giving you different kind of scenarios just to make you understand how exactly the case is taken by the examiner and controller into the patent office, my dear friends. Filing and drafting is one part, right? But to understand what happens over there, that is what we have to understand. Like I said, it is not compulsory to hire a patent attorney. It is not compulsory to hire a patent agent. Even you can present your case, even you can draft it and you can put it across, right? So the answer is, when it comes to an examiner, he will see is group A drug better than group A or not. If it is performing in a similar fashion, my dear friends, group A, it was killing 95% of bad cells, but it was killing 5% of healthy cells also. And even group B was performing on the same platform. If in case the group B would have proved group A is killing 5% of healthy cells, but we with our drug only 2.5% or 2% of healthy cells are being killed. So in that case, they show yes, the drug is much more effective as compared to group A. On the contrary, even they have to show it the benefit in terms of economic as well. And they would have, if they would have also proved it, yes, our drug is much more cheaper than group A. If this both these categories would have been accepted, my dear friends, in that case only like examiner will make sure that even this patent will have a value into the market. So you have to be very sure whether key what are already patented into the market, are you proving better than that or not? Proving same will not make any difference, will not help you in having a patent. You have to make sure you are better. To what percent, that examiner will decide, my dear friends. There is nothing known as percentage. Ki by this much percentage should be different or this much percent or increment should be there. It varies from industry to industry, case to case, my dear friends. Okay. So let's go for the next one. So as we said, ki by patent. So since we have more 8 minutes with us, let's understand ki since everyone is already a patentee, but still understand if you want to file your own patent, and this is the first time you already having your innovation with us, you already having your work with us, which are the forms which is required to you. All this forms is available on IP India website. Everything it is very easily accessible. Don't worry about it. Just to make you aware of it, ki what are the form which is required. Form number 1, form number 2, form number 3, 5 and 26. Few would question me, ki, wow, what is this? Be professional. What are you telling me form numbers? Tell me what with this form is for what? So that will be coming in next slide, my dear colleague. So there are three different entities. One is natural, small entity, and the other entity. Okay, natural is for all the researchers, like student community, and so on and so forth. Small entities is for the this one. When you talk about startups, I'll give you one of the this thing suggestions to you for everyone. If you want to save your 80% of your money, okay, on filing a patent, on government fees, like the complete government fees on a single patent, it works around 8,800 rupees. That is the approximately value. It could be 200, 300 here and there. Okay. And if you want the 80% rebate, my dear friends, what you could do, like if you're a final year project, okay, if they want to file for it for a patent, and if you feel yes, they have that kind of potential for it, what they can do, they can register their project as a product, okay, and they can register as a company and the Startup India. So once you register under Startup India and MSME, and both are of free of cost. Startup India MSME is completely free of cost. So once you register over there, you get 80% rebate for it. 80% of your money is rebated. I'll tell you one more very aggressive things to you, to all the researchers who are there with me. Few would say, sir, okay, they won't, you won't call me sir. If you would tell me, what if you said ki 80% is there. What if we are not able to draft it? If we want to hire that, we want to hire a patent agent or a patent attorney, the cost is very high. How to save that cost, Awab? Tell us that. I don't know how many people are aware of it or not. Government have created a group of patent agent and patent attorney. Okay, they will help you filing a patent for free of cost because government is paying directly to them. But the condition is that, my dear friends, you have to be registered on the Startup India. Like your student project should be shown as a product and registered on the Startup India and MSME. And then those people you can apply for the list of people who are empaneled by the government of India, and they will not charge you any single penny. The complete drafting se leke application, everything they will do it for free of cost. Government is very aggressive in terms of innovation. Trust me. With this, as of now, today in 2022, our ranking is 48th. In 2015, our ranking was very close to 81. So we have improved drastically in last 7 years, and more to come. We will definitely improve along. Okay. That is the reason government is focusing lots of efforts have been taken for innovation, and they have been supporting to government agencies too. So just we have to be very smart enough to how to utilize this government fund in a very appropriate manner. Okay. So the e-filing fees and the physical filing fees, the initial filing fees, okay, and then so on and so forth, the examination fees. So when you talk about the patent office, there are 4 physical patent office. So Mumbai is the head office, right? So Mumbai covers the following state and union territories. Chennai covers the following states and union territories. We have Delhi. Delhi covers the following states, and next is the Kolkata, the rest of India. Okay. So this was something which you can get it from Google itself. So when you talk about patent document, just a brief, short brief. What is the difference? Like the dimension should be very perfect for it. Top left should be a 4 centimeter. The margins, bottom right should be a 3 centimeters. A4 sheet, everything is like it is very purely common in all the documents what we do it normally. The only difference is that in patent drafting, every 5th line is numbered on the left hand side. That is the only unique point what we have in patent drafting application. Rest everything is very common. Nothing much different. Okay. So types of patent application, ordinary, convention, PCT application, division, additional application. Okay. We won't be going much into it. Convention is PCT is patent cooperation treaty. Both are like convention group of countries where you want to go apply for more countries at a time. Okay. Additional is something Permit and Anshuman and Preeti or Kamalef, all 4 are having their own patent. After like they already got a patent from Government of India. After 5 years, the team was still working on it, and they came with a few more advancement in their patent. So instead of applying for a new patent because they know the work is not so big, it won't get an independent patent. So what they will do, they will file an additional application for the previous patent to make their earlier patent much more stronger with much more claims, right? So they want to make their patent much more stronger. So that is possible. Even if you get a patent, you can make more claims and you can make your patent much more stronger into the market. That is known as from additional application. Okay. That's your form number. Form number 1 is known as application for grant for patent. Form number 2 is provision / complete. It depends upon us. How do we want to go ahead with it? Form number 3 is statement undertaking. Form number 5 declaration. Form number 26 is it is not compulsory. Form number 1, form number 2, form number 3, form number 5 is compulsory. Okay. Form number 26 is only when if you want to hire a patent attorney or a patent agent, a third party, when you want to if you want a third party so that they can present your case. Okay. Form number 18 / form number 18A is only when once you apply your application and when you want to request for the examination. There are 2 stages, my dear friends. One is you apply for application, your application is online, then you have like 40 within 48 months you have to request for the examination. Then you request for the examination, you have to present your case in front of examiners. Okay. And then it goes for the grant stage. That is the way it works. Let's understand the complete patent process. Complete process. How the application is processed under Government of India. Okay. We are having 2 minutes, so I think I need 3 to 4 minutes maximum to make you understand the complete process. Let's start with it. We'll be finishing up in 3 to 4 minutes. That's it. Let's go ahead with it. The first is application for a patent. My question is to the amazing audience. What are the form numbers which we have to apply? If you can mention the form numbers, anyone into the group. Form numbers which are required for the patent application. There are few form numbers which are compulsory form numbers. Compulsory form numbers which are required for the patent application. Form number 1, 2, 3, and one more, Dr. Sakshi. Very nice, Pawan. The form number 1, 2, 3, and 5. Bhavish, form number 26. Is form number 26 compulsory? Y or N? That's it. Form number 26 compulsory? Y or N? That's it. That's it. Just reply Y or N. Form number compulsory. Very nice. Thank you so much, Dr. Sakshi, Dr. Achal, Dr. Bhavesh, Soman, Dr. Sopyan. Yes, yes. Form number 26 is not compulsory. It is only required when you hire a third entity. It can be an attorney, it can be a patent agent, and so on and so forth. Only in that case you require for it. Okay, thank you so much. Let's go for the next step. You applied for application by using form number 1, 2, and 3, and 5. Okay. Application would take maximum 18 months. Nowadays, in priority stage, it is happening in 45 days, maximum, my dear friend. It is coming online with the platform. Someone has already put a link in between. One of the gentlemen have already shared the link where the application, with the application, you can already check your application. Within 45 days, it will be live. After application, you have to prepare for the examination. Okay. maximum time for the examination 48 months from the date of the application. It is 48 months, not once it is live, it is from the date of the application. Okay. So you prepare for the examination, everyone prepares for the examination, you submit and so on and so forth. You respond for the examination. When you respond for the examination, the committee will have two examiners and controllers would have two options. Either they will say yes, either they will say no. So let's understand, since the session has been very, very positive, we had an amazing audience with us who are very, very active, extremely supportive. Let's take it on a positive note. What if the answer is yes? If the answer is yes, my dear friends, congratulations to all the patentee. Assuming you already a patent owner, so all the patentee over here, the patent is granted. But since we had already discussed with by taking a Pratibha's case, what if the patent is granted, still anyone can oppose it? Yes. In India, we have post and pre-grant opposition, both. Even before the patent granted, you have pre and post grant opposition. So if there is an opposition, there is a committee would be formed. The opposition, the post grant notification will be open for 12 months from the grant date. And if someone is opposing, the committee would be formed. The committee will hear to both the parties. Group A has got the patent and Group B who is opposing the patent. Group A who has got the patent and Group B who is opposing the patent. The committee will hear to both the parties, A and B. Okay, let's see what would be the majorly options what they would have. One, the committee would say no. What we have granted to Group A is completely fine. Whatever claims have been put by Group B is null and void. So the patent would continue. Second would be option. Committee would say few of the claims that have been put by Group B is valid and Group A have to amend following changes, and then the patent would be continued. And the third option would be they would say no, the patent is rejected. If the patent is rejected, my dear friends, in that case, they would go for an appellate board, and then appellate, if we can fight for an appellate board, and the patent, either patent can be allowed, either it can be rejected. If it is allowed, it will follow the same process. If it is rejected, it will follow. This is how your patent application is processed under Indian patent law. So thank you so much, everyone. Thank you so much for being so supportive. I hope you got few of the concepts for IPR and patent. Thank you so much. You have been an amazing audience. Thank you so much for giving your valuable 44 minutes to me. Thank you so much. Thank you so much, Dr. Sakshi, Dr. Manoj, Pratibha, Kamil, Pramit, Dr. Diane, Dr. Sukhvinder, Dr. Suma Sundaram, Dr. Bhavesh, Dr. Achal. Thank you, Karpagam. Thank you, Doctor. Thank you. If I couldn't name you, thank you so much. Thank you.
Thank you so much, sir. I think, and I am sure that this insightful session would have been enlightened the participants about real life applications. Already you have taken such an interactive session, but I think I have one question to put on to you. How do we prevent hindrance of scientific progress by patent issues?
1 second, ma'am. I'll just. Yes, ma'am. Please.
Should I repeat my question, sir?
Yeah, please, ma'am.
How do we prevent hindrance of scientific progress by patent issues?
Ma'am, in that case, there are three different verticals for it. I'll explain you one of the verticals for it.
Okay.
When you talk about patent application, once the content is public, so it cannot be proceed ahead with the patent. Either it can be a scientific, either it can be a technological, either it can be a mathematical concept. Once it is public, it cannot be proceed. That is the reason it is always said, when you feel your innovation will really make a difference, either into three categories. One would be the industrial categories, one would be a commercial category, one would be a on a humanity grounds. Okay. Only in that particular three cases, you have to be smart enough where your innovation plays importance, right? So accordingly, you have to act. So once it is scientifically published, it cannot be taken ahead.
Okay, thank you so much, sir. I would now like to request Professor M.N. Huda, sir, to kindly present a certificate to Mr. Awab Habib Faki, sir, as a token of remembrance.
Thank you so much, Mr. Awab.
Thank you, sir. Thank you, sir.
As usual, your session remains too interactive, too informative, and on such an important topic, which directly or indirectly is touching and is of concern to everyone. This certificate is not for the purpose of certification, rather for the purpose of remembrance that you have been part of this amazing technical lecture series, 102nd lecture of IEEE BBI Camp, a weekly evening webinar series. So thank you so much once again.
Sir, I would like to request you to please accept this memento as a gratitude from BVI Camp family.
Thank you so much, ma'am. Thank you, Ayushi, ma'am.
This is all electronic mode. So your memento, your certificate, and your bouquet, everything is E into the nature. That is a change. Thank you so much. Thank you so much. We'll meet again, Mr. Ram.
Thank you, sir. Thank you.
Thank you,
Yes.
sir. I would also like to thank all distinguished panelists and participants who have continuously supported us by joining all through our webinars. Big thank you. We'll see you soon on the next coming webinar. Thank you. Thank you, sir.